Hello, welcome to this video on how to apply the law on occupiers liability. This focuses on trespassers under the Occupiers Liability Act of 1984. If you're looking for a video on how to apply with respect to lawful visitors, see the other video on that topic. So a little overview on this video before we begin. This was designed for A-level law students. My students study the AQA law syllabus, and of course this is going to be focused on how they particularly answer the question, but the skills are transferable. We're going to focus on structure. We're going to then absolutely focus on application of the law. There are plenty of resources which deal with explaining the law, which may include, of course, videos on YouTube or other websites and your own class resources or textbooks. So this assumes knowledge before we begin. So your explanation phase is down to your own study. This is forensically how to pick out the key points in a scenario. And then we're going to go through a simple work example to see how we deal with each of these elements. The structure I've always used, and the structure my students tend to use then, is this IDIAC formula, in which we first identify the problem as one of occupiers liability because of a trespasser. We would then define the law, as in what is occupiers liability, explaining each of the law. Now this isn't as straightforward as, for example, in negligence, where there are kind of three main elements and some sub-elements. It is more nuanced than this, so it's about knowing which to explain and which to apply. But of course, as I mentioned earlier on, this is down to your own studies first, or other videos. In terms of application, then that's what this video is going to focus on entirely. It will also deal with structure along the way in terms of in what order you should do things. And once you've applied the elements, conclusion, is there liability or is there no liability under the Occupiers Liability Act of 1984? Now, when applying this area of the law to a particular scenario in your exam or in your classroom activities, dependent on whether you're using this video to help, there are three things you need to consider first. Now, the very first thing, in fact, before these three things is to consider in your scenario, is there more than one person? Is there more than one claimant? Are they lawful visitors or are they trespassers? Now, of course, this is quite nuanced with respect to trespassers, but hopefully you've had enough time in class to go through and analyse what those situations are. We'll try and deal with those in as much as we can in this video too. Now, in terms of occupier then, we need to know who we're claiming against and why. Now, you are not claiming under the simple tort of negligence. You can do that kind of as long as there's a duty of care in certain situations. For this one, we're looking to identify who the occupier is according to the rules laid out in common law, because it's not actually defined in the Act. So the question is there a degree of control? Now, in terms of a degree of control, we can use Wheat and Lacan as an authority here. We then need to consider whether the tort occurred on the premises. So when looking at a scenario, identify in that particular scenario what the premises is and why it may be identified as such. So this is pretty similar to that in lawful visitors, but of course the situations are going to be different because we have a trespasser. So a fixed or movable structure as laid out in section 1.2 of the Act will give us a broad spectrum in which to work. So things such as ladders have been considered premises in the past, and of course you've got the more obvious ones, buildings, sheds, caravans and so on too. The list is almost non-exhaustive really. Now, in terms of premises, it can be part of a premises as well. If you've looked at burglary, you won't have done if you do the AQA syllabus, and certainly maybe not at this point either. But we need to make sure we know that part of a particular case can be. Now, in terms of trespasser then, we need to finalise our idea. Is this person a trespasser? Now, in outline only really, we can identify this. Now, usually you are a trespasser if you've either got no permission or you've gone beyond permission. So no permission would be you've not been invited onto the land or you've been objected to, so somebody has either directed their objections to the person directly, or it could be that fences have been installed or barbed wire has been installed, so there's something to indicate that this person does not want people on their land. So this could be made as a trespasser. In terms of going beyond permission, now there are three broad areas you may not be allowed in a particular area. You've got cases such as Pierce and the Coleman brothers, in which part of the place was not allowed to be in. You know, for staff areas, for example, are usually this kind of thing. The time, so you're not allowed to be there after a certain time. So you know, you're not allowed in the shop past opening hours, for example. At that point, you become a trespasser. And finally, purpose. So the reason you're at that particular place. So if you're doing something entirely different, then of course you would now then become a trespasser. So, you know, in the Calgarth, the staircase was referred to as you're allowed to use the staircase, but you're not allowed to slide down the staircase. You become a trespasser, just to give an illustration. And in terms of the purpose or activity, Tomlinson and Congleton Borough Council, a forbidden activity was swimming, and of course the person undertaking swimming was then become a trespasser because of the purpose, not being there for that purpose, and it was explicitly forbidden. So remember, there can be more than one potential claimant. Deal with each of these in turn. This is an overview, and of course you've got to identify in that scenario then, did the person have permission, or did they go beyond permission, and if so, in what way? Now, in terms of establishing liability, then once those kind of preconditions are met, we go through the Act and we essentially have to apply the Act, so section 1.3, section 1.4 and so on, just to make sure we satisfy all the elements, because all the elements need to be proven or disproven in some cases in order to have a successful claim under the Act. So we have common duty of humanity. This was a phrase used before the Act, but for the ease of purpose we'll use this today. So that's the first one we're going to look at, and then when we're done with this we'll see when the duty arises and what standard of care is expected of the occupier. So in terms of common duty of humanity then, we need to state and apply section 1.1a, and broadly speaking, in respect of any risk of the suffering or injury on the premises by reason of any danger due to the state of premises or things done or omitted to be done on them. So in this, essentially we have three ways then in which this can occur. Either the premises is dangerous, or there are things done on the premises which make them dangerous, or things which have failed to be done on the premises which makes it dangerous. So you've got to consider in your scenario, in what way could it be dangerous? Now sometimes this can be pretty innocuous, and so we have to forensically look at a scenario and consider, is there anything which you could consider dangerous? So you need to be kind of using your brain there a little bit. The second thing to say about that is, it's not the actions of the claimant, so the actions of the claimant are the cause of the injuries, and of course it's not the premises that caused them, and there will be no occupiers liability in that case. And another thing then, so from section 1.8, is that if the claim is successful, we can only claim for personal injury or death. We cannot claim for damage to property. So if that is satisfied, so if the danger arises because of the state of the premises, then we can move forward with our application. We then explain when the duty arises. And this is laid out in section 1.3a to C, and is supported by case law also. So in terms of having the defendant, first of all, needs to be aware of the danger or has reasonable grounds to believe that a danger exists. So in that respect, there are two facets. You become aware of the danger, which is a fairly obvious one, and in the scenario, the wording will be such that it's obvious to the person. Or you may have to apply that kind of reasonable test. Are there reasonable grounds? Would you think that the person would be the danger would be obvious in some way? If you do, then we need to consider whether the defendant knows about the person being in the vicinity, so whether the claimant is in the vicinity or people are close in the vicinity. So is there a reasonable chance or a reasonable knowledge of the person coming into the vicinity of the danger? Again, look closely in your scenario to consider, would that occupier know people are around? So this might be worded as such: he knows there are people using his barn, or there is CCTV footage of youths trespassing. So these kinds of things will be used to guide you, but you need to make sure we apply that carefully. And finally, the risk is one against which, in all the circumstances of the case, he may be reasonably be expected to offer the trespasser, some protection. So in this case, it's a balanced judgment or a balancing act. We need to make sure, if he knows of the danger, and he knows people come to the danger or there are reasonable grounds for either, then some protection should really be afforded to the trespasser. And if so, we have a duty, and they need to establish whether there is a standard of care or what standard of care needs to be looked at. And this is set out in section 1.4 of the Act. And it places a duty on the occupier as such to take such care as is reasonable in the circumstances of the case, to see that the trespasser does not suffer injury on the premises by reason of the danger concerned. So really, that's sort of an amalgamation of the previous subsections. We need to take reasonable care to make sure the premises is safe, and therefore no injury is suffered. So that reasonable care, we're going to come back to that in a moment, but some considerations then to consider whether it is reasonable. We have the occupier will not be liable if the claimant is injured by an obvious danger. If it's obvious to the claimant, then of course he's taking a risk, and therefore he himself is absolving the occupier of liability. Again, remember why this act was created as well. This act was created because of children. So you look at the case of British Railways Board and Harrington, or at least that was the kind of the starting pistol for this particular act, at least. So lesser duties owed to lawful visitors. So lawful visitors are afforded more protection, but we need to give reasonable protection in this case. And again, the court will normally find in favour of the defendant. So it's sort of like we normally say on the balance of probabilities in civil law, arguably the burden is heavily here on the claimant, and the judges are a little bit reluctant to find that there is liability. Now in terms of time and day and date, it might be relevant. Well, of course, you may expect some things to happen in the middle of summer that you might not expect to happen in the middle of winter, and of course the day-night kind of differences there too may be different. So we've got to consider, is that a factor in your scenario? Now, occupier as well doesn't have to spend lots of money to make the premises safe. This goes back to that test in negligence, in which we look at when we have fallen below the standard of the reasonable person, the practical precautions element. Practical precautions need to be taken, but if you need to go above and beyond, it's no longer reasonable, so you don't need to do that as an occupier. And again, Tomlinson and Congleton Borough Council here proves this point. The occupier will not be liable as well if they've no reason to suspect the presence of a trespasser. Now again, this really just harks back to section 1.3b. And in this particular context then, we have Higgs and Foster, for example, and we need to make sure that you know that there's a reason, or there is reasonable evidence that this person suspects the presence of a trespasser. So again, in your scenario, look at the wording. Is there evidence of the trespasser's presence known? And finally, again harking back to section 1.3a, the occupier will not be liable if he's unaware or had no reason to suspect a danger existed. If you don't know a danger, then you can't protect against it. If you don't have reasonable grounds to suspect a danger, then you don't need to protect against that danger. So we need to be absolutely crucial here to this, and of course there are several different cases such as White and St Albans and Keown, for example. Now with children, the rules are the same. Again, remember why this act was created. And some factors which then affect reasonableness. Now, I wouldn't go through every single one of these. The same as when you do negligence. Some risk factors are applicable, some are not. I would give these more of a light touch approach. This is something which can help you form an opinion as to whether the care taken was reasonable or not. So how likely is it that people are going to trespass onto the land? How serious is the injury? Cost and practicality precautions we dealt with already. How old is the trespasser? So if the person's younger, we need to be taking more care. Visibility and attractiveness of the danger. This concept of allurement with respect to children, for example. Relative obviousness, we've talked about that as well, haven't we? If it is obvious, then we don't need to take as much care, because of course the claimant themselves is taking that risk. Now sometimes we're just using common sense. I mean, I'm yet to meet a teenager with common sense, but then there we go. So yeah, apply as best as you can to that. And lastly, the occupier should not have to guard against an irresponsible minority. So usually, if it's kind of one person, two people who've done this, and we're not kind of having a pattern of trespass, then there's a possibility the occupier will not be liable. Now again, just light touch, but we do need to consider this, because if we think about how a claim is put forth, we need a duty, we need breach of that duty, and we need some damage as a result of the breach. Now give this a light touch approach, but do discuss it. So we've talked about the standard of care they're expected. Just comment, has the occupier fallen below that standard? And in terms of damage, is the defendant the factual cause? So but for the actions of the occupier or the omissions of the occupier, or more accurately, but for the state of the premises, would the injury have occurred? And again, we ask then, is the remote foreseeable or too remote? Is the damage foreseeable, or too remote? So if it of course is too remote, then we will not have legal causation and there will be no liability. So we need to actually look in this scenario, have they fall below the standard, were they the factual cause, and was the damage foreseeable or too remote? And once again, just give this a light touch approach. Now you may see this differently. We've got defences here. You may see them referred to as discharge of liability, so removing liability. So for example, in lawful visitors, we've got when a third party kind of does a job and it's their negligence which causes the damage, well, you're discharging your duty in that way. I've lumped them together as defences for ease of application, because I've found in my experience students tend to like to approach the work in a way in which they're establishing liability first and then considering defences or discharge. So I've lumped them together. If you do this in a different way with your teacher or with your however you're studying it, then of course use that way you're comfortable with, so long as all of these things are discussed. But for this video, we're going to use all of these as defences. We'll start then with warnings. These are an effective defence if they warn of danger clearly. Now this can be in broad terms or it can be in specific terms. Either way, it can be clear. Now section 1.5 of the Act tells us that the occupier may discharge the duty by taking such steps as is reasonable in all of the circumstances to give warning of the danger. In some cases, a sign might be enough. In others, you might have to put forth fences. You might have to build walls in some cases. So we need to, or even kind of rope around the area or blocking off the area in some way. So we need to make sure in your scenario, consider, is the warning enough? Is it clear, or should more have been done? And of course, if there's a child, it might depend on the age. A child might understand a sign, a child might not understand a sign. And if it is a child, you have to analyse the situation and consider, would a child of that age know that this warning was clear? Or would they understand the warning? And the two accepted defences then of contributory negligence is one in which is accepted through case law. It's not specifically laid out in the Act, but of course this reduces the liability. It doesn't remove it, because of course we've got some negligence, some occupiers liability, but the claimant has contributed in some way. In terms of voluntary then, section 1.6 tells us that your occupier owes no liability for risks willingly accepted by the trespasser. So there are things which we might not need to analyse here. So for example, if the warning tells us, that there is a situation and you took the risk anyway, you may use voluntary if the warning wasn't effective. So there are kind of plenty of defences here, aren't there? But with respect to voluntary on its own, this is almost like if a risk is obvious, then there will be no liability, and we've already dealt with that anyway, so it's sort of like tied into that. Once we've established then whether there is liability in the Act by looking at all the factors which give it duty, then considering whether they've fallen below the standard as a reasonable occupier, as it were, and whether causation is established, we ask, is there potential liability? Now you can be certain as to this, or you can kind of say that there is likely to be liability under this Act. Then we need to consider the potential defences, as I've just outlined in the previous slide, and then outline the possible remedies. The way these questions are asked normally is outline the rights and remedies of X. And so in this particular case, you would just outline the remedies. Now, dependent on the question, it depends how much detail you're going to need there. So for example, if it's in a large 30-mark question, then you're going to need to discuss remedies in a little bit more depth. So it could be, for example, as you're doing negligence, where you talk about special general damages and so on, and how they're awarded. So just make sure we brush up on that too. But as I say, this is focused only on application of occupiers liability for trespassers. So if you're using this video to help you go through a problem question, or you're revising and you're kind of working through a problem question or an exam-based question, then pause the video, rewind and go back to there and it will talk you through. What I will do now is talk you through a worked example. In that as well, I'm going to give you some exam tips like these. So the first exam tip is linked to if there's more than one defendant. Now if there's a claimant, sorry, let's just say claimant, ignore defendant. If there's more than one claimant, identify then who are the lawful visitors and who are trespassers first. And then what we've got then, we can deal with the lawful visitors and we can deal with the trespassers. That just helps then, because you can save time explaining why visitors are visitors and indeed why trespassers are trespassers, and then deal with the law to each claimant. It might save you a little time, but by the same turn, you may just wish to stick to each claimant and go through that way. Again, do whichever you feel most comfortable with. And a quick note about using precedent or case law. Now, obviously in this Act, a lot of it is laid out by statutes, so do remember to use statutes. Section 1.1a, 1.3 and so on. But making sure you don't spend too much time with facts of cases. Now, it might be the case sometimes where the facts are exactly the same as in a scenario, then you maybe discuss them to use the comparison. But actually, it's probably better just to stick to discussing the ratio decidendi. So this case gives us the indication that this is the law and this is how it happens in this scenario. Just making sure we use only the ratio decidendi, the legal reason for the decision and why it supports your point. One other note that I've not put on this slide is putting cases in brackets at the end. My feeling is it shows you know the case is there, but why don't we discuss why you're using it? If you know the case exists in that point, why not say it? Now sometimes saving yourself time in an exam could go against you in this case, because of course knowing why the case law supports your point makes you move up through those grade descriptors, and so ensure you look at the legal reasoning for the decision. So, worked example then. We dealt with this exact same scenario in the lawful visitors PowerPoint. And so what we're looking at here is a holiday for Homer, Marge, Bart and Lisa Simpson. They've gone to Springfield holiday camp for 2 weeks in August. The camp is owned and managed by Springfield Leisure Company. Now in the previous video, for lawful visitors, we've dealt with Homer as a lawful visitor, Marge as a lawful visitor, and Lisa as a lawful visitor. We're now looking at Bart this time. So Bart cuts himself badly and wrecks his jacket with a sharp knife when he sneaks into the kitchen in the camp restaurant, to make himself a sandwich. Now the door's not locked, but a notice on the door of the kitchen reads danger, staff only. So Bart is a trespasser. For this we need to identify that Bart is a trespasser, and so for his injuries he could make a claim under the Occupiers Liability Act of 1984. Give a definition of what occupiers liability is, and then we're going to explain in the law using your notes, any kind of video online, any summary sheets which you may have to explain the law. Make sure we're explaining it. Now in some way we did that earlier on in this video, but of course you need to go into more depth in terms of why cases, support points and so on. I merely outlined the cases you may be using some portions. We'll focus on the apply, okay, before concluding. So in terms of whether this person or Springfield Holiday Company is an occupier, the scenario tells us that they own and manage the premises. So that makes it really easy for us to say they're an occupier. Using the case of Wheaton Lacon, we have a situation where, of course, landlords and tenants can be considered occupiers, but they control the premises. So in this case, they are certainly an occupier. So we know who we're going to start a claim against for Bart. How about the premises? So a kitchen is part of a permanent structure, or indeed itself is a permanent structure. If it's inside a building, it's part thereof. So we need to say the premises is a kitchen is a premises without doubt. Now in terms of trespasser, well, Bart is a trespasser. He is a guest of the holiday camp, but he's exceeded permission as he's entered a staff only area. So at that point he's exceeded permission, he becomes a trespasser. So the rules are laid out if you study burglary, but of course trespassing is a tort, it's not something we cover on AQA. So this is what we need to know, give that kind of light touch, but of course it's a way in which you can be a trespasser, is to exceed permission. And we're going back then, once we've established who we're claiming against, why we're claiming against them, because it's on the premises, and if they're a lawful visitor, or in this case a trespasser, then we can use the correct act. And we're using the 1984 Act here because he's a trespasser, and we begin this with this concept of common duty of humanity. So first of all, we've got a minimum standard of care. This is what the common duty of humanity is. State and apply 1.1a. Now we've explained this already, but this is the state of the premises. Are things done or omitted to be done on the premises? Is that the reason for the injury? Well, in this case, you could ask that. Is the state of premises the cause? Well, if a knife in the kitchen is loose or the door's not locked, it's a kitchen, it is dangerous. You know, commercial kitchens could be considered dangerous. So if things aren't tidied away and it's unlocked, then one could consider this dangerous. However, you could also make the opposing argument that it's Bart's own actions which are the cause. Remember, he's made himself a sandwich, but presumably, although the detail is not there, that he hasn't cut himself with a knife. The knife has kind of been lying around as he's gone away. Then he has been cut and wrecked his jacket, as the scenario says. So it's a bit vague in the scenario, but of course that gives us scope to analyse the law. So we're going to fall down for argument's sake then on the side of a kitchen being dangerous, and that is the reason Bart is injured. If he can make a claim, what is he claiming for? Well, we know it's only injury. He cannot claim for the damage to the wrecked jacket, and this is set out by the Act in section 1 subsection 8. So once we've established, and at least on the face of it, common duty of humanity, it is the premises which are the cause, we need to establish if a duty has arisen. Now we spoke before about whether the person, the occupier in this case, is aware of the danger. Well, he's put a sign on saying danger, staff only, or if they put a sign on saying danger, staff only, so they know it's a danger. Indeed, a kitchen is an obvious danger to most people anyway, so this is without doubt satisfied. The second one leaves a little bit more in terms of analysis. So there's no evidence that the occupier knows Bart particularly is in the vicinity of the restaurant or the kitchen, but it's a camp, so you could reasonably assume that children are around at all times. So therefore, on balance, it might be considered reasonable then to lock the doors or put away the knives in the kitchen, or indeed other dangerous objects we can find in the kitchen, stoves, worktops, fridges, all those kinds of things could be considered dangerous and there's some way of harm. So we need to make sure you can't access this and prevent people from being harmed. Once we've established then if a duty arises, which we arguably have done, we need to consider the standard of care. Now this is what, again, we don't need to bog ourselves down with every single reasonableness factor, but these should help you use a judgment. So state and apply 1 subsection 4 in this case. Well, the duty is on the occupier then to take such care as is reasonable in the circumstances. Well, the occupier could easily have locked the door, moved the knives and other things which are dangerous. There's no argument really that this would have been reasonable for them to do so. And so we then need to consider the considerations. So reasonable on the face of it, but let's consider other factors. Now for adults, the occupier is not liable if it's an obvious danger. Well, it's an obvious danger to most people, but Bart is 10. So the argument here is maybe it's not that dangerous to him. Maybe he thinks a kitchen is a place where you make sandwiches, which he did. We've also got the concept there are lesser duties owed than to lawful visitors, so we owe them less care, but it's a child. So remember why the act was created. Harrington. The time and date may be relevant. No mention of time in this particular scenario, but if the kitchen's empty, maybe it's of a night time. Should we do more to protect people of a night time if there's no one there to protect the kitchen? So for example, in the daytime, would the kitchen member say, ask the child to get out? And we feel of course they would do that, so they can take more care by doing that. But if no one's there, should they do more care? Should they do more things to make sure it's safe while they're not there? Now it would have taken much to lock the door or move dangerous equipment. A simple instruction to staff would have covered this. And the occupier is not liable if there's no reason to suspect a presence of a trespasser. But here we've already said that they could predict a child may be in the vicinity. And we've already said it could be reasonable to assume the occupier knew a kitchen could be dangerous. Indeed, they have a sign saying exactly that. Are the rules the same? Now, we may need to consider the warning sign, but the rules are the same for the child, so we don't alter that in any way at this stage. But in terms of factors which might affect reasonableness, so just taking that little step further, how likely was the trespass? Well, it's quite reasonably likely. Kids are about, they will go where they want to. How serious was it? It could be serious to a child, a knife wound. The personal injury could be quite serious. Would it have been easy to take precautions? Yes, it would. Now, in your scenario, make sure you suggest some. In this case, we already have. We said about locking the kitchen, putting away all the dangerous objects and so on. Now, the likely age of a trespasser. Trespassers here are likely to be children. Okay, because if we consider adults are probably not going to go into the kitchen, but kids, as we say, will go where they want to. How visible and attractive was the danger? Well, it's not necessarily attractive, but it's certainly visible. If he's hungry and he sees a kitchen, there's a reason for him to suspect he might go in and make himself a sandwich, as innocuous as it sounds. How obvious was the danger? Well, it is an obvious one. Again, we've dealt with this again. Common sense. Well, a 10-year-old may not possess the same level of common sense. So in terms of factors, should you be expecting a 10-year-old to use common sense? And arguably not. Now the occupier should definitely possess common sense. And the occupier should not have to guard against an irresponsible minority. Yeah, it shouldn't have to. But indeed, with this one, we've got the potential of children not necessarily being a minority in a holiday camp. Now, breach and causation then. So once we've dealt with our kind of idea, these are factors we might consider. Again, don't go through all of them for breach, but as you've fallen below the standard, we've got to say yes. Okay, locking the kitchen is a basic thing to do if you know it's dangerous. So they've fallen below the standard mainly for that reason. Now, is the defendant a factual or legal cause? Well, Bart wouldn't have suffered injuries if the kitchen wasn't locked and he went in. And the damage is probably foreseeable. So we ask the question, is it likely if a child goes into a kitchen he might be harmed in some way? Without doubt, it's yes. So once we establish liability then, we need to consider is there a defence or can duty be discharged? Well, the warning sign is an effective defence if it warns clearly. Now the sign reads danger only. This is probably clear enough. Danger staff only, sorry. Perhaps this is clear enough. But we've said about warnings and that you might need to take other steps as well. In this case, we might need to lock the door too. That would be an easy thing to do. Indeed, is the warning reasonable steps? Well, that's what we said. Maybe not. It also might depend on the age of a child. However, Bart, in the context of a kitchen and with a danger sign, would probably understand it. If you're a fan of The Simpsons, you know Bart is 10, and he's been 10 since the show began. In terms of voluntary, so he owes no liability risk, willingly accepted. I think it'd be hard to use this defence with respect to a child. So for this, probably going to not use it. Has he contributed to his own negligence, so through trespassing or through using the kitchen knives? Potentially, so this might be used. So we've got two possible defences or two possible ways of removing liability there. So we ask then, is there potentially liability under the Act? Yes, there is potential liability under the Occupiers Liability Act of 1984. In terms of defences, the warning sign might negate liability. If you feel, if this was a scenario that it could, it might not negate liability, then state it with a reasoning, because like we said, more steps may need to be taken, such as locking the door. And what are the possible remedies? Well, if it's not successful because of the warning sign, then he wouldn't claim for anything. However, if successful, remember to say we could only claim for personal injury and not, in this particular case, damage to property. Okay, I hope this video helped then. So as I said, that's a worked example. If you're using this to help, go back to the beginning and kind of pause. You can slow the video down, you can speed it up if you need to. But if you want a written guide and you feel that'd be helpful, so you don't have to kind of write out everything, then I'm quite happy to send you one. My email address is reasonabledanlaw@gmail.com. Probably better to do it that way than in comments, so you're not giving your details out. I'll simply send you that and you'll be on your merry way. Good luck with your exams or with your revision, or if it's just you're just learning this for the first time, good luck with the application and I hope you enjoy. Take care.